Good afternoon, everyone, and thank you so much for joining us for another CLE through the Dallas Association of Young Lawyers. My name is Jay Spring, and I'm glad to be your moderator here today. Thank you for bearing with us getting started here as we've been having some technical issues. I'm delighted to have the chance to introduce a panel of three of my dear friends and mentors, Mr. Ross Williams, Miss B.B. Sanford, and Mr. Rob Bogdanowitz, as we're here today to talk about one of the topics that I think can be most opaque for young attorneys as they're trying to figure out the business side of the legal business. So kind of just to start off here, I'd love to talk a little bit, give the audience a little bit of a sense of each of your backgrounds, what practice area you're in, what type of firm you're at, and how you got where you are now. Rob, would you like to kind of introduce yourself to the audience?
Sure. Rob Bogdanovich. I practice at Burke Bogdanovich, a firm me and my law partner Aaron founded 3 years ago, I think. I come from a civil litigation background, practiced for years at a mid-sized Texas firm, then a national firm, and then a litigation boutique. So most of my work is business litigation. I do construction litigation, catastrophic personal injury, mostly on the plaintiff side, and wrongful death, et cetera. Soft IP litigation, trademark, copyright, stuff like that. But I'd say most of it's contract based. So that's what I do. Shuffle money
Great.
around.
BB, what about you?
Yep, I'm a plaintiff lawyer through and through, so I got your plaintiff side today. I started off doing personal injury, car wrecks, so I have that experience. I briefly did a commercial for like a year and a half firm, and now I'm a partner and owner at the Sanford firm. It's me and my dad's firm. We mainly do, we only do employment cases. We do employee rights. We represent those who are wrongfully terminated for their, we specialize in race, retaliation, discrimination, and whistleblowers, some qui tam stuff.
Wonderful. Ross, how about you?
My name is Ross Williams. I'm at Bell Nunley and Martin. I've been here since 2009. Before that, I clerked for a judge. Before that, I was in law school. And I've in general commercial litigation is the main part of my practice. But here we are, all the associates that come up are generalists in litigation. And so over the years, I've had huge intellectual property disputes. I do a fair amount of employee non-subscriber injury defense work. I've served as settlement counsel on the plaintiff side in injury cases. But the core of what I do is just general commercial litigation.
Great. So the topic today is case budgeting, valuation, and sort of the financial side of the legal business. I know that when I was a first-year attorney, I'd been out 2 or 3 months, and I had a partner who came to me and said, "All right, Jay, I need you to prepare a budget for this case." And I must have looked like a deer in the headlights trying to figure out how to do that. And I think it's one of the areas that we as a profession, especially in law school, really don't prepare young attorneys to address. So to start off, the backdrop, I think, for any kind of discussion about how you budget and about how you value cases needs to be the ethical backdrop that we get from the Texas Disciplinary Rules of Professional Conduct. And the Texas disciplinary, the rules, we'll just say that because it's a little bit of a mouthful, provides a rule 1.4 that a fee has to be reasonable. Now, that's not, it's the attorney's favorite word in the whole world, but it's not necessarily the most descriptive thing. Rob, if I'm trying to figure out what a reasonable fee is, how can I tell that?
So I think there's an aspect of that rule. Doesn't it say something about how essentially a reasonable fee is something a competent lawyer would not believe to be unconscionable?
That's exactly right. It's something that no competent lawyer would find unconscionable.
Right. So I actually did some research on this yesterday. I'm not aware of any ethics opinions that actually delineate specifically with hourly rates, et cetera, what's too much and what's too little. And I think there's a reason for that. I don't think that the powers that be, the attorneys, want to set some kind of a numeric standard. So it is kind of up in the air. And so that being the guidance, well, this is something a competent lawyer would know not to be unconscionable. there's a wide range. It depends on the practice area, what you're doing, how much experience you have, where you're located. And I think one really good guide that unfortunately the state bar doesn't publish anymore, they used to do a survey out to all the attorneys in the state of Texas on economic trends, which would be about income, geography, and hourly rates, since most of what we're going to talk about in this context is contingency fees, a little bit on flat fees, if you will, and then hourly rates. Looking at that is a great guide for young and older lawyers to see what lawyers are charging, what practice areas they're in, and what range they have. So something like that's a great resource where you can see, okay, I'm fresh out of school. What do I charge? We've heard of lawyers charging thousands an hour. Well, that's probably going to be a little ridiculous. But looking at something like that's going to be very helpful because there is no hard and fast specific number. And it's about what a judge and or a jury ultimately, if you're going to be litigating over fees, is going to find to be reasonable under the Lodestar test, which is a case that delineates, proving up your fees and what's reasonable. So the short answer would be there's no specific number. I really think that resource, which I think 2021 is the last time that they published it, is a fantastic place to look because it's pretty comprehensive. And you can see what lawyers are charging in different practice areas, and you'll get a good idea of what makes sense based on your practice and experience.
That's great. And so you talked a little bit about how judges look at those numbers. BB, I know in your practice, having judges review your fees is particularly salient for your plaintiff side practice. How does that work? What's that process look like?
Yeah, so so the statutes that I sue under, we get attorney's fees attached to them. So every day or week or month, I bill my time just like any hourly lawyer bills their time. An email, point one, researched something, however many, worked on a motion. The problem is I just don't send that bill to my client. I send it to a judge at the end of the day. And so there's different ways to do it. It's also depending on state court versus federal court. Sometimes it's tried to a jury. Sometimes it's tried to a judge. Sometimes it's during the trial. Sometimes it's after the trial. So if it's a jury, well, it's a jury trial. You just try your case on your fees, and then you have opposing counsel that will cross-examine you on the witness stand about the reasonableness of your fees, and you get your peers to come in and sit on the witness stand. If it's a judge, which is usually how it's gone, even if it's a bench trial for the fees, we just had one recently and was just sat up there and you talked about it and a judge listened and then made a ruling, or a judge will just look at it and they'll strike it off. So I know we talked about, so a judge is going to make that determination of what is reasonable and necessary. You're going to go through the Lodestar analysis. Opposing counsel is going to try to say, no, you're not worth that much. So you just look at opposing counsel's fees and you're like, well, how much do you charge? Oh, you charge $300 more an hour than I do, but do you have the same credentials or less credentials than I do? So I would say, look at your peers and what your peers are making. In the employment world, we liked what the state bar was doing, what Rob was talking about. We thought we could make it better or continue the process. And so some of us took on, not me, some of them took on that role and started gathering all the different records, public records of fees that have been charged. And we put it in called a yearbook, and we send it around to all the judges. And then we, gross up for, 2024 rates, what it would be like. Hey, this is my 2001. I got a judge that ruled I was worth $750 an hour. Well, in 2024, that would be however much it would be now. And so we use resources like those as well to compare with us.
So it sounds like when you're deciding what your rate is, you're looking towards the market generally and seeing where your competitors are, where your colleagues are. If I'm a young attorney, or maybe in a solo practice where I'm not setting my own rate, how can I get that information? Like, if I don't have access to the employment handbook, would attorneys be receptive to someone just calling up and saying, "I don't know what to charge. How do I do this?"
I think most people are pretty open to it. It can be personal, right? Because it's like oh my gosh, my worth is tied up in the hourly rate that I have that somebody else has artificially set for me. And then it's going to go up $50 every year or $100 every year or however it goes. I think you should talk about it with your friends. I think your peers should be open. I think that only helps associates the more you talk about it. Now there is a slight caveat in the law. If you are managing paralegals, your employer may say you're not supposed to talk about it, and then they could fire you for it. But if you're not managing anybody, no risk at all. Anyway, so slight caveats here and there, but you can also look this up on Pacer, like, right? Research cases of where people submitted attorney's fees and look it up. It's public record.
Great. So one thing I'd like to delve a little bit further into here, while we're on this general topic of contingency agreements, we have special ethical rules about contingency agreements. They have to be in writing. They have to have certain things that are delineated. BB, could you kind of walk us through in your world what you need in your agreements?
It's just a basic contract. Like, what would you want in writing is what the rules require. Put it in writing, say what your fee is going to be. And if you split your fee up, like, hey, pre-lit is one fee, and then it goes higher if it's in lit. And then if you go to trial, it's a little bit higher. Just put that in writing. And then at the very end, just summarize it all up. Hey, yep, this was the fee. This was the percentage split. This was what actually happened. These are the expenses. And it's just like an invoice. And that's really all the rules require you to do, is just be clear on the contingency fees and costs.
And one thing, Rob, that I know that we've discussed before is that you've handled some matters along with your partner Aaron, that where you've had contingencies where the basis for the contingency wasn't monetary. How does that work?
So as long as it's outlined in the contract, like BB was saying, what you can do is talk about the recovery being the value of certain property, et cetera. So whether it's real estate or something else, you can do that. It's just got to be very specifically outlined. I believe the Texas Supreme Court did away with having a interest in the client's avenue for recovery. I think there's some case law on that. That was something lawyers had done in the past. And if that's still good law, and I want to speak on it competently here because I don't know offhand, I think that lawyers tried to do that, but you can't anymore. But when it comes to the property, it's like, hey, if we're going to go and recover this property, et cetera, there's an arrangement by which there's a valuation to it, a valuation process, or it's just here's what we're getting out of it, and then the property split up, sold, auctions, whatever have you. It's not ideal. We have that clause in all of our agreements, but we of course much prefer to have the monetary recovery because it's a lot easier to delineate. So the answer is you can do it. It gets a little complicated, but again, as long as it's very specific in writing so that, however sophisticated your client is, they can read it and understand what exactly they're agreeing to pay you, whether if it's not monetary or if monetary recovery doesn't end up happening and it turns into something related to personal or real property, that's fine. So again, it goes back to make sure it's very clear.
Great. So with that kind of ethical background behind us with keeping Rule 1.4 in mind, I think we can kind of dive into the meat of today's discussion about valuation and budgeting. So Ross, imagine that I'm a client and I come to you. We're about to walk into some kind of mediation or we have some settlement opportunity. What do you do to determine what a case is worth?
Sure. So, I mean, it really depends on the case, right? And that's always the lawyer answer, I guess. But so in a vacuum, probably the best way to talk about this, maybe the most helpful way, would be to go through the kinds of things I might consider in any case, and then also maybe offer some thoughts about things that have been helpful for me in the past in trying to value cases for settlement. And so I don't let me not bury the lead. The thing that I would suggest that might be something that folks haven't thought about that much is some of the advanced research analytics that are available now through things like Westlaw. They've been around for a while now. I mean, Westlaw's advanced research analytics for all kinds of different things, including some settlement values have been out there since at least 2018 and available. for especially for the contingent fee world, I know there's various databases that compile settlement values when they're able to, when there's not a confidentiality preclusion on publishing that kind of information. And so that's another place to get information, and it can be really helpful because a lot of times when you're dealing with a large company, or even not that large of a company that just might be fairly litigious, if you can get some sense of what a case that's more or less similar to yours has resolved for, or that they've gotten a verdict against them for at some point in the past, that helps you in a negotiation, because it helps tell you where they'll go. And it also helps you kind of define for them what their risk is and what their exposure is as you're trying to negotiate them to the best resolution that you can. And that works on both sides. I mean, it's the same thing with or similar things when you're on defense. If it's fairly litigious, you can go and look at what outcomes have been for that party on the other side, maybe in similar cases, and even for their attorneys, because you can go look at what to the extent it's available, and there's not some sort of a confidentiality or preclusion. A lot of times you can find this is how this attorney has fared in this type of case before. In settlement, there's so many things that are fair game that don't come in court, and so that kind of thing, used by a mediator in the right way, or using a settlement discussion the right way, can also be pretty effective, because you can start to kind of drive a wedge between the other side and their attorney sometimes. So that's, to not bury the lead, or maybe the most sort of like high level thing. That's something that I like to think about. It's not always something that I use, but when I'm valuing a case for settlement, if that's an opportunity, it can give you some edges that you don't normally or necessarily have when you think about your more standard things, like, what's the amount of controversy in the case? What's the strength of the evidence and the arguments on both sides? Where are we at in discovery? What have we incurred in terms of fees? How much is owed? That's a big one. Those are not the same thing, right? How much is left to incur? What is the what is the client's financial outlook like? Are they running on fumes, or can they just fight as long as it takes and do whatever they need to do to get to the end of the best outcome that they can? What's the status of the scheduling order? Where is the case? Is it close to trial? Are we far away from trial? Are we pre-litigation? All of these can affect the way that you might go into the thing and the way that the other side is going to approach it, and tells you something about being able to predict how they may proceed, so that you can try to short circuit that if it's helpful to you. Who's your judge? What does this judge do with these types of cases typically? And again, that's something that's you can a lot of times go and find in analytics, and I have used that with clients before in trying to assess this type of case. Even this party, or in front of this judge, this is how we can see that they've come out. And that can be really helpful for a client, is because they just want something to grasp onto. They want something to know, to have some sense of how this thing might go, or what the outlook is. And the more information that you can gather and think about all these different factors, the more that you can give them a range or an idea or something that you're driving towards that's realistic, and some idea of how you're planning to get there. So these are the kinds of things that I consider when I'm trying to figure out, this is what I think this case is going to settle for at any given point in litigation.
That's all great information and wonderful things for us to kind of keep in the back of our mind. This isn't on the outline, so forgive me for going a little off script, but it's a question that occurred to me that I think will be interesting to our members. when you've arrived at a case valuation, and let's say that you've come to a valuation, this case is worth, to keep the math easy, $100,000, but your client, if your plaintiff side thinks it's a $10 million case, or your client thinks it's a $5 case if you're on the defense side. When you have that gap between your valuation and the client's valuation, how do you manage that?
That's client control is the first thing. Managing client expectations. I didn't mean to jump in, but I mean, that's the simplest way to put it. Some clients are unreasonable, and also it depends on the kind of case. I mean, when it comes to, say, an injury case, well, there's a lot of soft factors, some, pain and suffering, et cetera. Verdicts on those settlements can vary depending on the situation, the parties involved, the kind of injury, where it happened, what happened. That's where you see probably the most or you can see a lot of discord between a client and the attorney, perhaps in the employment context as well. Whereas, if you look at what Ross was just talking about and what you're asking now, it's like, all right, a client comes to you, you say $100,000 in controversy. Well, where does that come from? Well, it's because you had a roof put on your house and it cost $100,000 and it failed. So we've got at least something there to look at, say, hey, $100,000 was paid. It has failed. We've got something to look at in terms of actual damages. All right, what about cost of repair, replacement, et cetera? You kind of add those things together and go walk your client through it. And if you're having a lot of difficulty, of course, you want to make sure you put this stuff in writing. And ideally, they will see the light and understand that that's why they hired you in the first place. And that, you're the one who knows what you're talking about. They might show you some stuff they Googled, of course, and all that happens. But it's really going to depend on the kind of case. Sometimes it's a lot easier to do, with contract cases. Hey, we paid X dollars and we didn't get the product. We paid Y dollars and we got a defective product. A little more finite there and easier to kind of calculate when you talk about the base damages, because then the other stuff becomes gravy, if you will. Attorney's fees, interest, any kind of mitigation related damages. So, I try to steer clients to, let's look at the lower end and the corpus of what's really there. And don't worry so much about the add-ons, because that may happen, may not happen. And then that kind of can play into settlement value, et cetera, later, whether it's more or less, and how long the case has gone on for.
Great. That's all. It's an interesting kind of scenario that you find yourself sometimes in when you're kind of locking horn with the client. Bibi, I'd love to get your thoughts on how you value when you're making a demand. So when you are getting ready to go pre-suit or during settlement negotiations or mediation or wherever, how does it change from, if it does, how does that calculus change from when you're trying to advise a client about the realistic opportunities versus when you're trying to maximize a settlement?
Yeah, kind of bouncing off what Ross and Rob had said, I think it comes down, when you're talking to a client, it comes down to trust and the relationship that you've built with your client. And Rob's right. I mean, at the end of the day, you are, as the attorney, are the expert on the fees. You're the expert on the costs and the expenses and the value of the case. And so they have hired you for your expertise and for your advice. And so when you give advice, hopefully you have that relationship and that trust between them that they believe you. But in the plaintiff's context, they have hired you for a service, so I work for them. So look, I will give you my best advice. This is a good value. This is a horrible value. But the client makes the choice at the end of the day on what they want to do. How we value the case. And I think what helps me in those situations, and not everybody has this ability, is I only take cases that I want to take, that I believe in, that I think are good, that has the truth on our side, right? I don't have to represent anybody that has done bad things, that has done anything wrong, right? I don't represent people who are being sued or have horrible things in their closet. And so if I want to go to try, like if the client doesn't want to take it and wants to try the case, great, let's go try the case. I took this case on because I'm not afraid to try it. And so that gives me some clarity. And I think that helps in those ethical boundaries when I think, look, I think the client should take a good offer, but they doesn't want to, like, fine, you've hired me to try the case. I think it's a good case. We'll try it. I think in the employment context, cases are undervalued. I think in the personal injury context, cases are valued pretty accurately, depending on like the soft damages that Rob was talking about. In the employment context, a lot of the defense and maybe insurance companies tie damages based on lost wages. So if I'm going to try to settle a case, usually only my high wage earners settle, because that is something tangible the defense or an insurance company can see. Okay, here are the lost wages. Maybe I'll double that. Maybe I'll triple it. Maybe I'll whatever, right? That is something. Now, when you have a low wage earner, that's when it's hard. So what I look at when I value a case is the truth, documents, witnesses, venue. And do I have good law, right? I have to have the law on my side. What is the and then so I take that, I value the case on what I believe the value of the case is at the end of the day, after trial, after appeals, with attorney's fees included at the end of the day, and then I discount it for the risk involved. Okay, we have summary judgment, which is a huge risk in our cases. Motions to dismiss, that's a risk in your case. Depositions fall flat, that's a risk in your case. I would recommend, in my practice, personal injury, I think the risk is less high because there's not summary judgment. In an employment case, I would recommend discounting it by 50% because the risk is so high. So those are kind of things I would say, and maybe this is jumping into another topic, is do your analytics to figure out the value. Like read Moneyball, figure out what is the analytics of these cases. Look at your past cases, look at your friends' cases. What are they settling for? How long did it take? If a life of a case is 2 years, that's a long game to get to the end of that point. We also did some research. I did some research into Warren Buffett and how he values stocks. And I kind of incorporate some of that into how I value a risk of a case. So like look at other people who do high risk valuations and take what they do.
That's all excellent. So before we move on into the sort of budgeting portion, does anyone have any final thoughts to share with the audience on valuation?
I just to kind of piggyback off that real quick, we look at, especially in the contingent personal injury cases that we handle here, we will look at similar settlements. And like Ross had mentioned with the analytics, Westlaw has a lot of great tools and resources for you to investigate and research and look at other settlements or jury verdicts by venue, geography, et cetera. And so you can try to find similar cases with as similar as facts as you can and see what those cases have been tried for, what happened, whether defense verdict, was it a plaintiff's verdict, how much, et cetera. And then you can go from there and really try to, we use those in our settlement demands right at the outset and also in valuing the case. It's like, hey, this is what's happened. We're going to be filing in Dallas County, and this is the kind of injury that was sustained. All right, what are those cases? What do they look like over the past couple of years? And then you look at the specific facts of your matter. Do you have what you think will be good witnesses, poor witnesses? Are there any skeletons in the closet? Stuff like that. And it's very helpful. So, we use Westlaw particularly on that a lot. So you can get a lot of specific information.
That's wonderful. So turning now to, oh, I'm sorry, Ross, I cut you off.
I have one more thing to add, and I don't think that we've mentioned it yet, and it just came to mind, but can be really important in the case especially that justifies it, and that is doing mock juries to try to if the case justifies to do the preparation or to even get a mock jury on certain issues. And you're trying to value what the case is worth. I mean, that can give you do one or three of those, it's going to give you some sense of how a jury may come out and the things that in your case that maybe you need to think more about, emphasize, de-emphasize. It can be helpful for those reasons too. For valuation, that can be really helpful and a driving factor.
For anybody in our audience who may not be familiar, could you describe generally like how the mock jury process works?
Sure. I mean, it can differ so widely depending on what it is you're going for, but basically the way that we approach it is go to a jury consultant, tell them we want to mock the case, or we want to mock this issue, that issue. You're going to talk about where the case is in discovery, what you have, how much is left. And then you put together, they help you to put together a panel of folks who are brought in and paid to sit as mock jurors essentially, And you can do everything from putting on the full case and having actors as witnesses or colleagues act as witnesses, to just presenting something much more limited on certain issues. And then ask them to go back and deliberate, come back and make a decision and tell you how they came to the decision. It can be really helpful for the valuation piece, and then we could get into all kinds of other ways it can be helpful, but that's another valuation aspect that is worth thinking about, whether or not your case justifies it.
It's an incredibly useful tool. I had the chance early on when I was a first year to observe a mock jury, and getting the chance to listen in on the deliberations, I think, is one of the most insightful insight building processes of that entire components of that process. So
Pretty terrible, actually. Hearing how the sausage is made, some of the stuff that come out of these people's mouths and their mock jurors, then you wonder what's going on in the real jury room. So yes, it is insightful, but you're like, God, you got to be kidding me.
So I'd like to talk a little bit now about budgeting, the kind of other side of the coin. So one of the first budget issues that, and at least in the hourly world, many people are going to run up to is setting a retainer. So Rob, I know you had some thoughts about how you determine what the retainer would be, how you manage the client expectation around it. What are your thoughts on that?
One of the first things that's really important, because early on in my practice, when I started to generate a client base, I wanted to bring in as much as I could. And of course, the lower your retainer, typically, the easier it is to snag a client. But that can be problematic. And so really, of course, you have to look at what your rates are. What are the folks at your firm charging, or what are you charging? Say you're a solo. What kind of a case is it? Let's just take a business dispute over a contract. And then you want to look at what's in controversy if you can. Sometimes it's easier than other times. So you're like, all right, client comes to you and says, I have this contract dispute. I paid X dollars and I didn't get the product. Or again, like I said earlier, or it's defective. So you look at what you're going to be suing over in that context if you have to. And then what you want to do is first make sure the client understands your retainer is not going to necessarily be a reflection of what this case is going to cost. Some clients, even if they're more sophisticated than others, just get it in their head that, oh, the retainer was $10,000. That's what I'm going to be spending. Not at all. Having that frank discussion about, hey, this is what a retainer is. It is my security interest to make sure that, of course, we get paid. And you can structure retainers differently, whether it's you pull from them and they have to replenish it, or you just keep it until the end of the case and or apply it to a final invoice. That just stays there as security. And so again, you look at the amount in controversy, or at least I try to. You look at the folks that are involved. What kind of businesses, what kind of individuals, what's the potential for recovery? Is insurance going to be involved? And then you try to make sure that you set it such that, you don't want to have a client come to you who has a legitimate $1 million contract dispute. Let's say they spent that and the contract went awry afterwards, whether they didn't get what they expected at all, or it just didn't work out. That's probably going to take some time to litigate, and setting that expectation at the beginning. Like, this is not something that they necessarily will roll over on. I tell clients, potential clients, if I had a nickel for every time I sent a demand letter for a plaintiff with a demand of an amount of money and it settled immediately, I would have retired by now. But it just doesn't work that way. So you look at it and go, all right, this is what it may look like. It might take years. You want to set an appropriate retainer, because you also want to make sure these folks can stay in the game, because litigation sucks. It's a roller coaster. There are busy months and there are not busy months. So, you look at it and go, all right, and I'm going to give an example here, $1 million dispute. It would not be unreasonable, particularly with the rates we charge at our firm, to ask for $25,000 as a retainer. Sometimes, especially if injunctive relief is involved or is going to be sought, that's a lot of work at the outset. Might be more than that. But you just want to make sure that there's no magic slide or scale as to what is appropriate, but you just have to remember, hey, if you're really going to lowball that retainer, you're probably buying yourself some problems later down the road. And also, I will say this, if you have a potential client who's hemming and hawing about what your retainer is, and you believe that it is a fair, sensible retainer for the dispute that you've been presented with to handle for that potential client, walk away. Do not negotiate your retainer. Stand by what you say, because believe me, you are buying yourself a bill dispute at some point, and it's not worth it.
Sure, absolutely. So when we move past the retainer phase and we're starting to look at budgeting more generally, BB, what are the different types of costs, fees, things that I should anticipate when I'm starting to figure out what a case might cost me, the resources I'll have to put in?
Yep. So I'll let obviously Rob and Ross talk about the billable side of it. But for me, I work for free until the very end. My fortunes rise and fall with my client. So if my client loses, I don't get paid. So really all that we, in our case budget, it's expenses and costs. And the theory in the employment world is the employee who I represent is able to get another job. And so they can pay for the fees. And so the employee usually pays for the fees. And so we walk through that with the client. Starts off with a filing fee. It's going to cost $500 to file a lawsuit. Then there's not going to be a lot of money, but eventually you're going to get to depositions. You get about 10 depositions a case. Those cost $1,000 a pop, right? Give or take. That could be up to $10,000. There are experts in cases. They have an hourly rate of a couple $100 each. Is it just going to be a report? Is it going to be testimony at a deposition? Are they going to testify at trial? That could be 20 to 30,000 per expert. And then, so kind of all that together, I usually estimate for my clients it's going to cost $25,000 to $50,000 per person. Per case. And so if you have a multi-plaintiff case, those costs are split between the plaintiffs. If they can't pay that, so there's different ways, right? So they can start saving now, they dip into their 401k, they start paying me monthly just to so they have, they're putting something in the pot every month. Some plaintiff attorneys do retainers like Rob was talking about, but just for expenses. And so they take like $5,000 to $10,000 up front that they start pulling from. We don't do retainers. But those are the different options that you have. I will say sometimes there are hybrid contingency fee agreements that some of our peers do where they charge a lower hourly rate and then also a lower contingency rate. And so you can do that. Just make it clear in the contract and the fee agreements and talk through that like Rob was saying.
Wonderful. So Ross, I know that you had some thoughts on the method that you use to estimate costs like depositions and mediations. Would you mind sharing that with our audience?
Sure. We'll start with depositions. So, first question is going to be, are you taking or defending, right? If I'm taking a deposition and I'm trying to set up a budget of what it may cost, the rule that I try to go by just to get a rough idea of what we're looking at is for every hour of deposition time I expect at least 2 hours of prep time. So that's just a start, right? You can adjust up or down based on all of the circumstances that might be at play. If this is the key deposition, the key witness in a huge case, and there's a million pages of document production, you might be spending a little bit longer than 12 or 14 hours to get ready for that deposition. But that's where I start, is a 2-to-1 rule, and that gives that can help give the client some idea of what they may be looking at on expenses. Other things that you have to think about in factoring in or in figuring out what a deposition is going to cost, or all the various options that you have on your menu of stuff that you can get from vendors, right? Do you want real time court reporting being played out in front of you as you're asking questions? Are you actually going to use it or not? It's not, it's not super expensive, but it's not free either. Do you want roughs? Do you want rush transcription? Do you want video? All of these things you have to consider when you're taking a deposition, and some of them too when you're defending. I've seen counsel on the other side of the case walk in to the deposition with a little camcorder and set up at the worst possible job of the HUD angle in front of my witness, and then just hit record and start asking questions. I swear them, start asking questions, right? And I was like, what is going on here? And there's provision in the rules that allows that. Now you get a question whether or not the best way to go about it. It might be the most effective for you to go about it that way, but it's possible to do. And so, you know, if you're trying to save money, or if this is not a witness that that you
Ross, it's called litigating economically. Okay.
Yeah, there you go. You got it. So she may be one, right? And that's okay. It can also make your witness look terrible when the other side does that. So, but anyhow, those are the kinds of things I think about in deposition. If I'm defending, I expect it, if it's going to be shorter than a full day, I would expect prep to be, I can do it in an hour. I usually tell folks 1 to 3 hours. If I expect it to be a full day deposition or it's an important witness, I'm going to tell them it's going to be a full day. And if I think that we actually need longer, we may take longer if it's a key witness in a big case. For defending, those are the kinds of things I think about. For mediation, you got to think about mediators' fees. Those aren't cheap these days. Some are very reasonable and some are extremely expensive in my estimation. And so that's your first thing, is who we're going to use for the mediator. Then you have to think about, for mediation, I usually expect to have a half day to a full day to get together my mediation position statement and get it done and out the door. Sometimes big case might take longer, right? And then also the thing you have to think about is your experience with this mediator and with this opposing counsel. Are they ones that always run it to the end of the mediation and then want to have follow-up negotiations after? If they are we talking about one phone call? Or are we talking about a month of time going back and forth and back and forth? It can be anywhere in that range. And so talk to people that you work with, talk to your friends and colleagues at other firms about your opposing counsel, about this mediator, and about how it typically goes. And just know that experience can change from one to the next, but at least gives you some guidance and some idea what to expect and prepare for. And all that goes into the expense of it.
Thank you so much. And I'm sorry that I've just gone off camera. I'm having just a little bit of technical difficulty here. I'd love to turn now to, and this I think was a question for the panel, rather. I'd love to turn to the factors that you're going to look to in a civil lit matter overall that will impact the budget. What's the universe of things that you need to be thinking about so that you can articulate to your client how much they might be looking at spending on this case?
I'll start in first on this one, and then open up to everybody. So the first thing I think about is the first thing that typically happens, right? Which is the client. What are the client's demands going to be? Do they want you to pursue scorched earth litigation? If they do, that's certainly going to factor into the budget. And I try to make them understand what that's going to cost. That they may be coming in, if that's really what they want, I may be asking for 10x our standard retainer amount, right? So, and that will tell you if that's really what they want and what they are willing to go after or not. So the first thing is the client. Next thing I think about is if we know who the judge is, who's our judge going to be? Or who do we want the judge to be? Because if you're going into arbitration or something like that, sometimes you can pick, or depend if it's a very small jurisdiction. So opposing counsel, if we know who opposing counsel is this someone who is going to sit back and just kind of ride the wave through to mediation or trial? Or is this somebody that's going to send you a letter every day? That can vastly change what this case is going to cost. And then again, using the advanced research analytics that are available out there to help assess all these things can really tell you what you might be looking at and how much work you might be looking at. Amount and controversy, difficulty of the case, if there's particular evidentiary issues that are difficult or research that needs to be done, that can get really expensive really fast. So those are some things I think about.
On that note, we're talking about budgets a little more globally. The folks on the panel know I'm a Star Trek nerd, and I do think that this is something that I think is really helpful to keep in mind when you are budgeting, especially at the outset. When Captain Kirk would ask Scotty how long it would take to repair the warp drive, famously, Scotty always artificially inflated how long it would take. It's like, I need warp drive now. Scotty's like, you got to give me 4 hours. Scotty knew it probably would only take an hour or two, but he did that. So one, under promise, over deliver, and two, to set expectations. And then you can do the same thing with budgeting, really. And my recommendation would be, is especially if a client says, I need a budget. Some of my bigger corporate clients love to have written budgets at the outset that may get modified through the case. Folks that do insurance defense are probably very familiar with the fact insurance adjusters love budgets and need them. And they usually have some forms, et cetera, that you need to fill out. And those attorneys get really familiar with how to budget a case at the outset, which sounds difficult because you're like, I just got the file. I don't know the totality of circumstances. Always overestimate. I like to give ranges, and I like to make a breakdown where I go, here's the first stage of the case. It's fact investigation. And I'll outline those things in a written budget. Fact investigation, correspondence, initial document review, et cetera. And we give them a range based on the hours that we think it's going to take. And again, I overestimate that so that ideally we're going to fall within that range. Unfortunately, a lot of that comes down to experience. You know, it's easier with, say, a deposition because you can say it may take in Texas state court up to 6 hours on the record. Okay, great. Let's say you want to budget for that using a deposition. Talk to your client, and then you look at how long you're going to take to prepare. You get that hour range. That's a dollar value. There's the range for it. A deposition, 6 hours, maybe. Might be shorter, might be up to 6. But remember, there's downtime in between when there's breaks. If you have a 6-hour deposition, you might be there for 8.5 hours. And that might all be billable. Making sure you account for that when you're giving your clients those budgets are important. So, you know, when we do this, we outline those different sections: discovery phase, pre-trial phase, preparation, mediation, et cetera. And so those are the important things to look at. And so, you know, like I said, it's remember that you want to underpromise and overdeliver, especially on budgets, and companies will appreciate that. And also making sure that if things change, you update that as soon as you can. Maybe at the outset, you go, all right, I think there's only going to be 5 witnesses. Let's say there's 5 witnesses to depose. That's what you have in the written budget for your client. Okay, a couple months in, turns out there's going to be 10. Make sure they understand that there's potentially double the amount of witnesses being deposed. And here's how that increases your cost.
The only thing I'll add is, oh, go ahead.
Oh, I'm sorry, BB.
Oh, thanks. The only thing I'd add so us, the only budget obviously is the expenses. But if you get a super litigious side, like the scorched earth defendant against you, that will affect settlement value usually. So if somebody treats my client horribly over and over and over again, and they say mean things about my client, and they do the scorched earth, usually that has a negative impact for settling on the plaintiff side, and it's going to go to trial more often. So that's how I kind of use that.
That's Ross's MO on the defense side.
I think that's a good lesson for all of us to remember to be civil to our plaintiff side friends. We've just gotten a question from the audience.
I got to say something, Jay. Nothing will get me to come off you faster than what Rob just said. I have to say, everybody that doesn't know me, it's the exact opposite. I try to take the roadhouse approach. I'm nice until it's time to not be nice, and that almost never happens.
Absolutely. I think everybody who knows him knows that Ross is a gentleman through and through. So we've just gotten a question in from the audience about when you should consider firing a client for non-payment of fees. In our last couple of minutes here, does anybody have any thoughts on that?
As soon as you possibly can. Realistically, the longer you drag out that issue, when you have a client who's struggling to pay the bills, and as much as you may want to continue representing them, remember that this is how we put food on our tables. And so the quicker you can rip off that Band-Aid, the better. So it's going to vary by circumstance, but that's also where a retainer is important, of course, and making sure that you're protected on the end. And so if you see that happening and the discussion starts to pop up, and a couple months deep, it's, this is really killing me, have that frank conversation with them and see if it's going to be an ongoing issue. And realistically, you don't have to be rude about it, but it's like, hey, if you can't do this, I can't continue to represent you. And you just don't want to get them to be too far in the hole. I've been there and had that happen to me where I'm like, I just thought they could get out of it and they never could. And then you're 6, 8 months down the road going, I am never going to get this money, am I? And you're still working for them. So you have to rip that Band-Aid off very quickly, unfortunately. It's a very unpleasant conversation to have, but it's necessary because we are not banks. We don't loan money. You need to get paid.
It's a business, end of the day. We have another
I think
question
Ross
coming.
wants to say something real fast.
I'm so sorry. Being on my phone makes it hard for me to see when people are trying to talk, so I apologize. I'm talking over y'all a bit. Ross, what do you got for us?
Just very briefly, I agree with what Rob said. And the thing I would add is, to the extent that you can fire them before you hire them, that's even better. And so what I mean by that is know to look out for red flags. If you're talking to them about a standard retainer amount and they're giving you pushback, that's a red flag. If you're telling them this is you're asking for injunctive relief, emergency injunctive relief, it's basically a trial in 2 weeks. It's going to cost a lot of money to do that, and they're pushing back hard on that, or really pushing back at all. Just consider, is this a red flag? Do I need to think about whether or not I want to get into this? And better than they do what it's going to cost to go through with the case. Do you think that they're going to be able to fund the litigation? And if you can avoid that, I know it's hard to do, especially when you're a young attorney and you're trying to build a book of business, but it's better to have a zero than a negative huge number. Just think about that.
Makes perfect sense. Makes perfect sense. It's not business till you actually get paid on it, right? So we have one more question coming in from the audience. What do you consider to decide to elect for a video versus non-video deposition? Anybody have any thoughts on that?
I'd recommend to always do it if you can afford it. The only reason not to be is if truly your client can't pay.
That's my general belief as well, because you get some good, you can see the mannerisms, et cetera, play it back for a jury or the judge later on. Yeah, that's huge. If they can afford it, I always go for it. And if it is a budget conscious thing, seeing whether or not that's going to be a difficult witness, you have to try to elect like, all right, I know witness X is going to probably just not come off well. That's the one that you probably want to elect to video versus someone else who's probably say it's a third party witness or whatever have you, that is just going to give you a little bit of information and it's not really, doesn't have any skin in the game per se. Those are the differences, but I love, always video if you can.
Great. Well, with our last couple of minutes here, I'd love to talk about what happens when your budgeting and your valuation didn't quite go right. So, and Rob, I think you teed this up well when you talked about over-promising and under-promising and over-delivering. When you find yourself in a situation where you are, unfortunately, the case is becoming uneconomical, like your budget's not accurate and you're going to have to go, what do you do in that situation when you've said this is going to cost you this much and you find out it's going to cost them double?
Well, my budgets are always accurate, but no, being serious, that's also why I give a range. I mean, that does happen. It's always going to be more expensive than even the attorney will think at the outset. I've been doing this a while, and invariably that is the case. That's why, at least with what I do with my clients that want budgets, want them in writing, I like the range idea, because sometimes, especially at the outset, my range is incredibly broad, even for certain sections. Like they'll see a discovery section chunk, and they're like, well, this says discovery alone will cost between $25,000 and $135,000. What? That doesn't help me. And I go, that's because I got this case from you a week and a half ago, and I'm giving you the initial budget that you want. I don't know the totality of what's going to be produced, except I can tell you, with my experience, I'm expecting the other side to produce significant documents, and that's where that range falls in. I don't know how many witnesses there'll be. And so my recommendation would be, because it will always be more expensive than you think, if you can, a range is the best way to protect yourself. Again, under promise and over deliver, but if you give them that wide range, especially at the outset, and it's not just discovery is going to cost 50 grand. I mean, sometimes you have to do that. Some insurance companies don't, they have forms, they won't let you put any range in. If you have the freedom to do it, a range is great, and then tighten it as the case goes on. Look at what you've been billing. Look at what's happened and how much they paid to date, and then you can really start to tighten it up. Is what I do. And so by the end of the case, that range has gotten way tighter, and we're trying to fall within it. But also, if you can't do that, making sure they're immediately apprised as to what's changing and why. And so it's not like, oops, I just sent you another bill and that's triple what you thought. Make sure they know, hey, this is what's happening, and it's going to increase that budget. So you kind of protect yourself at the same time, even if you're going to go quote unquote over budget.
I think my best piece of advice for the plaintiff side is don't ever let one case put you out of business.
Sure, that makes perfect sense. If you have so much risk associated with one case that it can become a, instead of bet the company litigation, it's bet the firm litigation. Sure. Well, we have about 60 seconds left. Does anybody have any concluding thoughts, any last pieces of wisdom? Ross, what have you got for us?
The thing that I've seen and heard that's been helpful in my experience from the beginning of the case is the following metaphor. Think about like we're trying to build a bridge across a river. Each day we go out, we build it as far as we can towards the other side. And each night goblins come along and they tear off as much of the bridge as they can. We have to come back the next day and keep building the bridge. And so that is the uncertainty of litigation. And then all along in the case, you're explaining to them, okay, this is what's happened. We couldn't expect this, or we expected this to possibly happen, and it has. And so now we have to spend more to continue trying to get the bridge to the other side of the river. If you can take them on that journey with you, then they understand from the beginning it's uncertain. And then as things come up, they know these are the kinds of things that can come up in litigation. It's not a total shock for them.
Right.
As an associate, never cut your time. Let the partners do it for you.
Totally agree. That it cheats everybody if you cut your time without them knowing.
Great. Well, thank you guys so much for joining us here today. That was a wonderful panel. So to thank you all again, Ms. B.B. Sanford, partner at the Sanford firm, Mr. Ross Williams, a partner at Belt Nunnally, and Rob Bogdanowicz, a partner at Burke Bogdanovich. We can't tell you how much we appreciate experienced attorneys making the time to come and teach our members, because this is the way that we the way that our young attorneys learn, and without the volunteer spirit from people like you, we just wouldn't be able to put on these presentations. So thank you so much for coming by. For our participants here today, Sherry Harris has posted the course number for today's CLE in the chat. Please make sure that you write that down. You will self-report your own credit through the State Bar of Texas's website. And thank you all for joining us at another DAYL CLE, and I hope to see you guys at another one of our events very soon.
Thanks, James.